What's this? Good afternoon. Welcome to Division 3 of the Court of Appeals. Today's panel includes Judge Dunn and Judge Moultrie, and I'm David Yoon. We have 3 cases on our docket this afternoon. The first case is People versus, I don't know if I pronounce CS, 20CA1360. And I see the council seated. Let me go over a few things before we start. As you probably already know, you have 15 minutes to present your argument. An appellant may reserve rebuttal time, but you'll need to keep track of your own time. We have 2 things to help you. One is a digital timer that will show how much time you have. And we also have 3 light system. The green light comes on when you start, yellow light comes on when there's only 5 minutes, and red light comes on when your time is up. We are recording and live streaming the arguments, so if you have any confidential or sensitive information, please withhold mentioning it. And we apologize in advance if we mispronounce your names or your clients' names. If anyone in the courtroom has a cell phone or electronic device, please turn it off. And when you come up to the podium, there's a toggle switch to the right side where you can raise or lower the podium. Unless counsel have any questions, we may proceed. Appellant.
Good afternoon, Your Honors. I'm Lisa Wise from the Public Defender's Office, registration 27553, appearing for Ms. Sayas and the defense. The opening brief raised 8 claims of error. I think all of them are meritorious, but in particular, I think the jury instructions in this case were seriously flawed in terms of omitting the element of causation and intervening cause. But today, I really want to focus on the vagueness challenge to the constitutionality of the child abuse statute. And the reason I want to focus on that is because I think the court's going to have to address the constitutionality of the statute, irrespective of the outcome on some of the substantive claims. I'm not sure. There's a way that it might not be required, but it might come to that. So and do you want me to explain why?
Actually, before you jump ahead on the jury instructions, I want to clarify something, because hypothetically, if we were to, first of all, you talk about the causation as an element, and then in your reply brief as a sentence enhancer. Do you agree it's a sentence enhancer? That's my first question.
No, I think it's an element.
1A, linking 1A to 7A.
1A is not a crime standing alone. 1A only exists as a crime with 7A. 7A is an element.
Well, under the Supreme Court Dunaway decision, I'm not sure that's entirely correct. I read that 1A is establishing the crime of child abuse with 3 alternative ways to commit child abuse. Do you read it differently?
I do.
And what is your support for that?
It is Dunaway. It's how I read Dunaway. Because it is true that the crime of child abuse describes 3 ways, right? And those 3 ways are described in 1A, but 1A is only part of the crime. 1A has to be read with 7A. 7A has the mens rea in it. 1A does not have a mens rea in it. You can't have a crime with no mens rea.
So you don't think you can commit child abuse without any result or injury?
No, you can absolutely commit child abuse with no result or no injury. That would be a misdemeanor under a different provision that's later. But the 3 ways of committing child abuse that are described in 1A, that's only one part of the crime. That's the actus reus.
Well, then how do you, your opening brief then says the jury actually found a misdemeanor, and that's what we should enter or direct the trial court to do on remand if we were to agree that the jury was misinstructed. So I'm having trouble understanding this argument with your request that we order an M2 conviction.
Because the jury found, the jury's findings did not include the causation connection that's in sub 7A, but they did make findings that would be that would constitute the misdemeanor crime of committing those three things without any harm ensuing. So you could do one of those three actions. But if you do one of those three things and there's no harm or injury, then the statute goes on to explain that it's a misdemeanor. So if you don't explain the 7A harm, the death, knowingly, recklessly cause the death, if that is not proven, if you only prove what was set out in the jury instructions as they were instructed, it mirrors what the misdemeanor would be.
And could you just respond to your opposing counsel's argument that we can, if we were to find an error, that the correct remedy would be allow the prosecution to either retry or elect to have the court enter a misdemeanor conviction?
There is authority for that. That's absolutely true that there is authority for that. There is also authority saying that it could be vacated entirely. It's up to this court what path it's going to choose. However, though, if it's going to remand to give the prosecutor the choice whether to retry on the F2 or enter the misdemeanor, in that situation, this court would have to determine whether the misdemeanor is constitutionally permissible. And that's why I wanted to reach the vagueness claim.
Before you get there, can I ask you a question?
Sure.
The pattern instruction 6-4.09, the comment says, it is not necessary to submit a special interrogatory asking the jury to determine whether the child abuse resulted in the death if the instruction defining the offense is drafted in such a manner that in order to find defendants guilty, the jury necessarily must find that the abuse resulted in death.
That's right.
Do you think the instructions as a whole that the court gave fits under this or doesn't fit?
Absolutely does not fit. And I think the interrogatories that were tendered would have fixed that.
I understand, but why doesn't it fit?
Because Dunaway says that of the three types, okay, so if the prosecutor in this case had elected and proceeded under theory 3, which is cause death, if they had proceeded under theory 3, then the instructions would have been sufficient to prove the death, right? The causation and the death. Then the instructions would have been fine. However, the prosecutor in this case did not elect between those three theories. They proceeded under all three theories. And if any one of the theories is legally insufficient, then under Dunaway, this conviction cannot stand. That's why. So, for example, theory A is cause an injury. That's not the same as causing death. So the jury wasn't required to find death. If they all thought that an injury was caused under the first theory, they weren't required to find causation and as to the death.
So if the court had included the standard interrogatory, would that have been sufficient?
Yes, absolutely. That was the error. The error was not giving the interrogatory. Because Dunaway says that it's not enough to instruct on the three theories that are in 1A. It says you have to go on and instruct on 7A, unless you're doing the misdemeanor. If you're doing the misdemeanor, which requires no harm or serious bodily injury or death, then you could just do 1A. But actually, I'm not even sure that that's true, because the misdemeanor would require a mental state. And when you go lower down, the misdemeanor says knowing, reckless, or negligent would be an M2. So, but the instructions in this case require the jury to find that the defendant acted knowingly with respect to 1A, so the mental state was there. The only thing that's missing is the causation. Are there other questions about the jury instructions? Yeah, the way that I read Dunaway is that if the prosecutor doesn't elect between the three theories of child abuse, if one of those is factually flawed, that's totally fine, because some jurors could find the first theory, some jurors could find the second or third theory. It doesn't matter. Unanimity is not required in that regard. That's fine if they're factually flawed, but if any one of them is legally flawed, then the conviction falls. That's what Dunaway says. All right, so moving on to the vagueness test. The test is that a law violates due process if it fails to provide a person of ordinary intelligence fair notice of what is prohibited, or is so standardless that it authorizes seriously discriminatory enforcement. And the best way that I can explain what happened in this case is through an analogy. So let's say that I'm out in my front yard every day cooking hot dogs on my grill, and the girl across the street comes over every day, and I give her a hot dog every day. And her mom comes over, and I give the mom a hot dog too, every day. And the mom sometimes brings her own hot dogs over, so I know she's got her own hot dogs. And sometimes the mom helps me cook the hot dogs, so I know the mom's capable of cooking. But then one day I decide I'm not going to feed them anymore. And I tell them, I'm not feeding you anymore, and I'm moving away. And I move a half a mile down the road, and I don't see them, and I don't talk to them. And more than 2 weeks passes, during which time I don't see them and talk to them. And then the girl turns up dead, and there is no cause of death that is certain. She dies of unknown causes. Have I committed murder in that situation? Have I committed child abuse? Because if I have, then that means that I have a duty to go around knocking on every neighbor's door every day to make sure the children are fed, even though they were healthy when I last saw them, and even though the parents are capable of caring for the children. And that's what happened in this case. I think under that standard, this statute is vague. And one more note about the legal standards reference to discriminatory enforcement. I want to add that Macias is an African-American immigrant from Haiti in a virtually all-white jurisdiction, and that during the course of this litigation, one of the prosecution witnesses, who was a law enforcement officer, repeatedly referred to the defendants with the N-word. And so she's particularly vulnerable to the risk of discriminatory enforcement by the government in this case.
But wasn't there some, I'm sorry,
Go ahead.
in reviewing the record, wasn't some of that withdrawn? Wasn't there an exhibit kind of related to that was withdrawn by the people? Or no?
That witness testified, and her
Okay.
whole testimony was stricken ultimately, I think by agreement of the parties after a lot of litigation about it.
Okay.
And yes, there was an exhibit about it, and I think that exhibit was stricken as well. I'm just saying that goes to the vagueness in terms of the potential for discriminatory enforcement and Ms. Sayas's particular
I'm sorry.
vulnerability to it.
On your vagueness, what part of the statute, it seems like you're making a sufficiency argument.
Well, they're connected, right? Because if this court finds that the evidence was insufficient, you don't have to reach the vagueness issue. But if the court
I know,
finds...
but you were starting off with your vagueness argument. So what provision in the statute is vague?
I am challenging the words cause in cause injury. I am challenging the word permit a child. And I am challenging the word engage in engaging in a pattern.
But you're just picking words out of context. It says, if such person causes an injury to the child's life or health. What's vague about that?
It's vague as applied to my client, because if she stopped feeding someone and that is a cause of an injury, then that is vague, because there is no discernible standard by which a person can determine when their behavior is criminal or
So
not.
that now you're saying it's not a facial challenge, it's as applied challenge?
It's as applied,
Okay.
yes. I believe that's in the briefs.
And permits a child to be unreasonably placed in a situation that poses a threat of injury to the child's life or health.
Yes, did I permit it by walking away and stopping to feed them and moving my family to a different place? Did I permit that injury 2 weeks later when the child died from unknown causes? Did I permit that?
I mean, isn't that sort of the point? It's the question for the jury to assess all of the evidence that might go to cause, interactions between the defendant and the child at issue. I guess I'm not understanding how the fact finder having to consider all of those things makes the statute vague as it applied to your client.
Well, first of all, the jury didn't receive correct instructions on causation or on intervening cause. So their findings are not necessarily accurate, okay? And second of all, this court has an independent duty to determine the sufficiency of the evidence, even after a jury convicts. Even if the jury had been correctly instructed, this court has an independent duty to review the sufficiency of the evidence and make sure that it's substantial and sufficient to sustain the convictions.
As I understand it, though, you're asking us to consider your vagueness as applied challenge based on the evidence you're selectively presenting to us, in some cases as a hypothetical. There was much more testimony from Mr. Blair about your client's conduct and instructions to the members of this spiritual group. So
Yes.
why couldn't the jury consider all of that in context, and why would that make the statute vague as applied?
Because Ms. Sayas, what she said is that children should no longer be fed from the food that the group ate from. Okay, she did not say, there's no trial evidence that she said the children should not be fed. There is no trial evidence to that. The state and I strongly disagree on this point, and I urge the court to look at the record. Blair said, Ms. Seuss said, the children should not be fed from the food that the group ate from. She cannot be punished from that. That is absolutely protected religious speech. If I say that a house is haunted, don't go there, I am protected in saying that if that is based on my spirituality.
Didn't Mr. Blair also instruct that the children be banished to the car, that no one leave the property to get food, that food from the
No.
food bank is
No.
impure?
Yeah.
I have read his
If she-
testimony.
I'm sure you have. If she's, okay, first of all, Mr. Blair is not always clear on who said things and who heard them. There's no testimony that Miss Seus specifically told Miss Bramble, the mother, and Miss Eden, who is the nanny. There's no testimony that she ever told those people, don't leave the property, don't go near the children. And in fact, Miss Bramble was staying near the children. That is exactly why she knew when they died. She's the one who found them and came and reported it to everyone else. So, no, Blair never said that my client told everyone or told those people in particular. She may have told Mr. Blair that the car was filled with dark spirits, but she may have told Mr. Blair not to leave the property. But where is the evidence that she told other people this? It's not there. I'm out of time. Thank you, judges.
Thank you.
May it please the court, my name is Erin Grundy, registration number 41271, and I represent the people of the state of Colorado. The people ask that this court affirm the defendant's convictions for child abuse resulting in death because the instructions as a whole instructed the jury that they had to find that the child abuse resulted in death, and the verdict forms reflect that they did find that beyond a reasonable doubt. Additionally, the statute provided ample notice. It was neither vague nor overbroad as applied or facially under the circumstances of this case. I'm going to start first with the jury instruction question. So as far as the jury instructions, we look first, I'd like to focus on the preservation question. So the instruction that the defense actually proposed in this case was an election under Court of Appeals Archuleta that required the prosecution to elect not only between the hybrid mental state of child abuse, which in this case is knowingly and recklessly, but also between the three theories of commission. While each of those included cause death, there was not an interrogatory proposed that actually related to causing death. So the defense did not propose an interrogatory that tracked 6-409 INT, and that issue is not preserved, so the people assert that plain error applies to this situation. Turning to the actual instructions. When we look at jury instructions, we look to two questions. First, did the court abuse its discretion? Judge Yoon, you look like you have a question.
So I'm trying to find it, but I recall there was a conversation regarding the friend case, and I think Ms. Cias's counsel objected that the element of causation wasn't there. So isn't that sufficient to preserve the issue?
Your Honor, I disagree, and I think if you look to the February 5th jury instruction conference, it happens over February 4th and February 5th. At that point, what we understand from the defendant's objection and is that it's an objection to unanimity as to the three theories of child abuse under Archuleta. The court walks through a pretty detailed analysis that cert's been granted in Archuleta at the time of this trial, and it actually gives a unanimity instruction in jury instruction 19. So here, the trial court cured the actual unanimity question because the friend issue related to dealing with multiple acts. And they specifically reference, well, the jury could have found that it was in North Carolina. The jury could have found something else. After that discussion, the court agrees to give the modified unanimity instruction that it actually gives in instruction 19, and the parties move forward. When the court comes back with the modified packet on February 5th, the defense indicates they have no additional objections and does not indicate that there's a lack of a jury verdict with respect to causing death. Additionally, when we look through all of these instructions, what the parties look at is that this was child abuse resulting in death. This isn't a situation where we sometimes have a jury trying to ascertain, did the defendant cause bodily injury or serious bodily injury? So we need an interrogatory to distinguish exactly what their verdict is. And we disagree with the construction of 1A and 7A as being together to create a crime. 1A creates a crime. 7A defines the penalties and sentence enhancers. So if we had the jury verdict without the resulting in death, we would have the M2. Because we also have resulting in death contained in the elemental instruction in 3 different places, including the bridge. We also have it in the jury verdict, which specifically says child abuse resulting in death, knowing or reckless, guilty, and then lists each of the victims' names. We have a jury verdict and the burden of proof applied to that. There's no question here as to whether the jury was finding and entering a verdict for child abuse resulting in death. And of course, that is the language of 7A. 7A doesn't say cause death. It says child abuse resulting in death. This instruction exactly tracked that statutory language. While I agree there is some room for clarity, instructions could often be better, but here the instructions as a whole inform the jury.
Ms. Grundy, under that interpretation, wouldn't an elemental instruction always be sufficient? Why would you ever do the interrogatory?
It depends on the interrogatory and the verdict form. So sometimes you see a verdict form that just says child abuse. If the verdict form only said child abuse, we would only have a jury verdict on the M2, absent an interrogatory. Here, they combine the interrogatory and the verdict form together, which is not exactly the pattern, but of course the patterns are non-binding. So because it was combined in the verdict form, both with the mental state knowing and reckless and with the resulting in death language in that verdict form, we don't need more.
Can I break that down? So
Sure.
are you saying instruction 16 itself is sufficient, or the combination of instruction 16 and the verdict form?
16 and the verdict form.
But 16 alone doesn't satisfy the requirement under Dunaway, right?
I think that that's probably true. One thing I would note is that instruction 16, in variation from the pattern, does list child abuse resulting in death as the crime. It also indicates, in conjunction with the bridge instruction from first-degree murder position of trust, that this is child abuse resulting in death as a lesser included of first-degree murder victim under 12. And then the second page of that instruction also makes clear that the jury can only enter a verdict for either first-degree murder or child abuse resulting in death. But here, we also have that verdict form, which is effectively an interrogatory for the jury finding resulting in death as a component of their verdict.
But the verdict form doesn't require any finding beyond a reasonable doubt. So how do you square that with Apprendi?
So I think that if you combine instruction 16, which says child abuse resulting in death, and that you must find all of these elements beyond a reasonable doubt, along with the verdict form, we have an indication here that the jury applied this to the crime that was in front of them, which was resulting in death. It's illogical to assume that they would have severed the resulting in death language that was contained in element 4 and applied it to only one theory. But even if they did, the evidence here absolutely shows that that is the theory that the prosecution proceeded under. It was a pattern of malnourishment that resulted in the child's death. That same conduct also violated the other 2 provisions. It caused an injury. It also placed the child in a situation that caused an injury, or that endangered their life or health. So under all 3 theories, the cause of death was attached. And I don't think that the jury would have read this separately to only apply to that 3rd theory, especially when the title of the instruction, the subsequent page, the bridge instruction, the defendant's theory of defense, and the verdict form all referred to the crime as child abuse resulting in death.
So when I look at the verdict form, it looks like it's more like a title, child abuse resulting in death knowingly and recklessly, and not a suggestion that it's like special interrogatory.
So I think that's because they were
Because it
only
said,
given.
did the child abuse result in death, yes or no? There's no such question. It's pick whichever the crime, murder in the first degree or child abuse resulting in death. It doesn't really require a finding that it resulted in death.
I disagree, Your Honor. It says in its plain language, child abuse resulting in death. And then the option is guilty or not guilty. If you're finding the child abuse didn't result in death, the only verdict there is not guilty. Here, the prosecution could have presented, or had the defense not objected, which they did, some of the lesser includeds that go with it. They could have given the M2. They could have given the child abuse negligently.
You don't think this is just a title? Murder in the first degree, you're capitalizing child. It's capitalized. Each word is capitalized. It looks like it's a title rather than a finding.
Your Honor, I think it is a finding. When the jury signs that guilty verdict, they are finding it for a specific crime. That crime was child abuse resulting in death.
Okay.
It necessarily and inherently includes a finding of resulting in death. We can't separate what this is or require pattern instructions with a yes or no that appears nowhere in the statute to substitute for the actual statutory language, which is in 7A. Pattern instructions are helpful. They are not law.
Just so I understand, why wouldn't you look at that? There's two different crimes listed in child abuse resulting in death and go to instruction 16 to see if the elements were satisfied.
Yes, where it also lists resulting in death.
But I thought you just told me that 16 in and of itself doesn't satisfy the Dunaway case.
The pattern instruction under 6409 in and of itself would not. Here we don't have that pattern instruction. We have several important modifications. First, it appears in the bridge instruction. It comes as the lesser included, that is child abuse resulting in death. 6409, the title is only child abuse. We also have another important modification to subsection 4 of this instruction, which is that under the statute, under 1A, it can be child abuse under a pattern that ultimately results in serious bodily injury or death. Here, serious bodily injury was removed from 7A because that just wasn't an issue. So only death remained because the parties were addressing this such that death was the issue before it. Child abuse resulting in death was the crime discussed, the crime charged, the crime everyone discussed. And I'd also like to point out the verdict form gave another very important option here. It wasn't simply murder or child abuse. It was also not guilty. Had the jury found not guilty, they would have checked that box, and the verdict forms permitted that. But here, they checked the box that effectively included the interrogatory of child abuse, knowing and reckless, resulting in death. That could have been structured a number of different ways. It could have been knowing and reckless as its own checkbox. It could have been criminally negligent. Criminal negligent had that lesser included been given, and it could have been death, SBI, or no injury. Any of those could have been given. But here, where it was given with the combined mental state and the actual resulting in death language in the verdict form, that alone is enough to show us that the jury found the elements of the crime beyond a reasonable doubt, especially when we consider the instructions as a whole and not in isolation, which always referred to this crime as child abuse resulting in death.
Ms. Grundy, I think in your answer brief you say if we were to conclude that the felony was improper, it shouldn't be an F2, then it should go back and the prosecution has discretion to elect what to do. So what of the other, if we were to hypothetically agree with that concession in your answer brief, what's left for us to decide? Because as I read the opening, most of the arguments are geared towards the felony. Do we need to reach the constitutional? Do we need to reach the evidentiary? What's your position on that?
No, Your Honor, I don't think you would need to reach any of the claims. Of course, under Sepulveda, you'd reverse and the prosecution can retry this under the F2. I don't think there's any question here because it's not a case where there is insufficient evidence. It's a case where the parties disagree what the evidence shows. But here, giving all inferences in the light most favorable to the people, it is certainly sufficient to return it to the prosecution to retry if this court determines there's an insufficient verdict. I think that the res geste and 404B issue would certainly occur differently at trial today because the court would have the benefit of Rojas.
Yes.
So I don't think there's any need to address that. Child hearsay is always a moving target, so it's something that the court would need to reassess at the time. So I don't see any reason why this court would reassess that. It's not one of those issues likely to recur. I also don't think you need to address the vagueness and overbreadth challenge. Here, the statute gives notice as to exactly what conduct is prohibited, and that is harming and killing children. This isn't a simple question of someone being deprived a hot dog. This is absolutely a question of the jury received evidence that showed that the defendant engaged in a pattern of conduct that resulted in malnourishment and resulted in the death of a child. It also shows that her direct conduct implicated the other portions of the child abuse statute, and this statute is neither vague nor overbroad.
And do you agree that 7A is an enhancer versus an element?
So 7A is an enhancer. So I think that 1A creates child abuse. What's a little strange about the way that the child abuse statute is written is that the mental states appear in subsection 7, but I think that what the effect of those mental states is just explaining, if you have satisfied child abuse under 1A, here are the penalties depending on which mental state and which type of injury applies. So if you have the child abuse resulting in death that is knowing and reckless, it's the F2. But if you have knowing and reckless child abuse resulting in no injury, it's the M2. So I agree 7 spells that out, but 1 establishes the actual crime. 7 just explains how the penalties work when you combine the mental state and the actual injuries. But there's no additional elements that I think 7 has to prove. It's simply that we have the sentence enhancers contained there. If this court has no further questions, the people would ask that this court affirm the defendant's convictions. Thank you.
Thank you both for your fine arguments. The case will be deemed submitted and a written opinion will issue in due course. So, if appellant is ready, we'll proceed. And I'm sorry, the case is United versus Wheat Ridge, 23CA1366.
Thank you, Your Honor. Good afternoon, Your Honors. Counsel, may it please the court. I'm Jacob Hollers, number 50352. I represent United Advertising Corporation, or UAC in this case. I'm joined by my client representatives, Mark Giordano and Brett Kelly. Under our system of law, we as a society chose to have written laws so that every ordinary person could know what the law is and plan their affairs accordingly. For this system to work, though, the law must be published for all to read. In this case, the defendants have sought deference to an unpublished, unknowable interpretation of an unambiguous provision of the Wheat Ridge City Code. And that unknown interpretation doesn't track the plain language of the code provision, and it seems to shift to suit the whims and needs of the Community Development Department at Wheat Ridge. UAC wanted to enter a rare lottery to fill one vacancy in the limited spots of 16 that Wheat Ridge allows for billboards within its boundaries. So what did UAC do? It consulted the code. It read the code, read its plain language, developed a billboard that it felt met that plain language, expended resources and time to plan that and submit the application. However, much to UAC's surprise, after it applied for the lottery, it was rejected, although it met every criteria to be a billboard under the code. The Community Development Director rejected that application, finding the billboard was not oriented to an interstate highway because it was not, quote, clearly visible from an interstate highway. The words visible and clearly don't appear anywhere in the relevant code provision, which is the definition of billboard. It was undisputed below that the billboard is the appropriate size, is in the appropriate district, and only advertises off-premises goods and services. So the only issue was whether or not the billboard was oriented to an interstate highway.
So can I ask you the question regarding ambiguity?
Sure.
So why isn't the ordinance susceptible to more than one interpretation? I get your point. The ordinance doesn't mention anything about visibility, and it just says oriented to interstate highway.
Sure.
But-
And a couple of points on that. One, and I will get to this in
Okay.
a moment, it's not directly responsive, but I want to preface that I don't think the issue of ambiguity was raised below, and I think the district court violated the party presentation rule when it addressed that issue. But setting that aside, the provision is not ambiguous because, UAC's proposed interpretation is reasonable, and the city's is unreasonable. It's unreasonable for a number of reasons. First is that it does not abide by the plain meaning of the word oriented. The city has never been able to point to a dictionary definition of that word that includes any notion of visibility. It seems there's been a concession that the dictionary definition of oriented only speaks in terms of pointing or facing in a particular direction or at a particular object.
But don't you have to read the whole ordinance, right?
Sure, I agree with that.
And my understanding is the ordinance requires the sign, the billboard, to be in excess of 50 square feet, right?
Correct.
And it also has to be utilized to advertise a product or service
Yes,
while oriented to the highway.
correct.
So why can't we, looking at the context, given the purpose of a billboard is to be seen?
Sure. And from an economic perspective, no one's going to apply for a billboard that can't be seen, but setting that aside as the ambiguity issue, additionally, the city's interpretation is not reasonable because it ignores the grammatical structure. And as the case law we cite in our opening brief and our reply brief establishes, an interpretation that doesn't follow the plain meaning, doesn't follow the grammatical structure of the sentence, isn't reasonable as a matter of law and can't create ambiguity. Additionally, the city, when it adopted this code, I believe in 2007, when it adopted the word oriented to, it had another provision of its law that spoke about exception permits. And part of what an exception permit could be is a sign that, among other things, is easily visible from the street. The city showed a clear intent that that was not what it meant by oriented to. If it wanted to engraft a visibility requirement into the definition of billboard, it had previously done so and showed its ability to use those words. And so the use of the word oriented to is a deliberate choice to be something different than visible. Additionally, as the record at page, one moment, uh, 223 of the court file shows billboards can exist in the B2 zone within Wheat Ridge. The record at page 223 has the map of the B2 zone, and as your honors can see, that zone includes areas that are well away from I-70, which also at least implies the city didn't intend for a visibility requirement to be included within the definition of billboard. If they wanted it to be visible from I-70, they would have kept it within a certain distance of I-70 or 76, which is partially in Wheat Ridge.
Mr. Hollers, I guess getting back to Judge Yoon's comments, I mean, you make good points about the plain language and the grammar, but again, the overall context, I think you've pointed out, no one should interpret an ordinance to be unreasonable. Without visibility, isn't there some unreasonableness to just applying the straight facing the highway if the whole point is advertising?
No, Your Honor, and I think that the City of Brentwood case from the Tennessee Court of Appeals that the defense cited in their answer brief and that we discuss in our reply brief goes to that issue. In that case, there was a dispute over whether a billboard was along one road or another. There was a scenic highway and a regular highway. The code there prevented billboards from being along a scenic highway. There was a billboard placed between these two roads, but facing the non-scenic highway. The court found that it wasn't along the scenic highway because it wasn't oriented to the scenic highway, because it was facing a different road. That's the exact interpretation that we've advanced here, and the Tennessee Court of Appeals found to be a reasonable interpretation 17 years ago in a very similar case. So while from an economic reality point of view, it may be unreasonable to make a billboard that nobody can see, what would be the point? But from a legal standpoint, when it comes to what billboard means here, you have to read it by its plain language and apply dictionary definitions, and courts, at least one other court has done that. So it is a reasonable interpretation. If there are no further questions on that issue, I want to talk about the notion real quick of deference. There's some dispute in the briefing on how much, if any, deference Wheat Ridge is entitled to. Wheat Ridge seems to take the position that it's entitled to basically automatic deference, regardless of whether there's ambiguity in the statute. But that's not the law in Colorado. And this court's opinion in the Foothills Park and Rec District from just last Thursday makes that clear. In paragraph 31 of that opinion.
District court found ambiguity and then deferred, right?
Correct, but it did say that deference is not automatically given. It is earned, even if it's ambiguous. The agency seeking deference has to show, and deference really isn't the right word, it's persuasive value, that its interpretation is entitled to some persuasive force or weight. And there's a number of factors that
I understand, but I thought you were saying that the city's arguing that we defer even if it's clear and ambiguous. I don't think that's what district court found. District court found it was ambiguous and then gave the deference, right?
Correct.
Okay.
That is, but the city in its answer brief here, and I believe its answer brief below, argued they get deference no matter what, whether it's clear and unambiguous or whether it's ambiguous. And so I want to make clear for the record that that is not the law, as this court in the Foothills decision last week held when it said that it may defer but need not, and is not bound by any agency interpretation. And our Supreme Court in 2021 in the Nieto versus Clark's market case 2021 Co. 48 was invited to apply federal deference standards and expressly rejected that invitation, and specifically said that it's unwilling to adopt a rigid approach to deference that would require courts to defer to reasonable agency interpretations of an ambiguous statute, even if a better interpretation is available. In other words, even when there's ambiguity, courts in the state don't defer to agencies. They review de novo, they look for the best reading, and the best reading here is UAC's interpretation. In addition to the reasons I've already discussed why UAC's read is the better read, on top of the Tennessee Court of Appeals case that I think is highly persuasive in this case, we have additional reasons, and as well, I spoke about the deliberate choice to use oriented to instead of easily visible from that the city used. Additionally, the city has not been consistent in its interpretation of the word oriented to. The most salient aspect or fact for this argument is in 2018, there was a billboard application for just one block south of where UAC's proposed billboard would have been. And the billboard, as proposed, would have been almost entirely blocked from view from the interstate because it was mostly below grade. It was below the road surface of I-70. It would have required a variance above the maximum height requirement of 32 feet, or maximum height limitation, up to, I think it was 50 feet. So in excess of 50% upward variance. The city, in that instance, knowing the billboard wouldn't be visible, allowed that billboard into the lottery, and it actually won the lottery. They then couldn't get the variance, and so couldn't build, so it went away. But that shows the city's interpretation of oriented to is a moving target. Additionally, the city hasn't published its interpretation anywhere. There's no formal guidance documents. There was no notice and comment or any feedback received from relevant stakeholders as to how to interpret this term oriented to.
So is an argument that they've exceeded jurisdiction then, or what's your argument with respect to that?
Our argument is that they have abused their discretion by misinterpreting the law, at least on these points we're talking about today. We have raised in our briefing that they also abused their discretion by making a decision, the BOA at least, that was not supported by the record evidence. I'm focusing today, though, on the legal argument because this court's review of the legal interpretation is de novo. It's for this court to decide which interpretation is better. If there are no further questions, I yield the rest of my time. Thank you. Or reserve it.
Good afternoon, Your Honors. Jeffrey Klingsborn, 38997 for Wheat Ridge. May it please the court. I think there's a lot that the parties agree on here, perhaps more than Mr. Holler's presentation would indicate. So I just want to go straight to the nub of the question, which is almost purely a question of statutory interpretation. What does the term oriented to mean in the context of this statute? There are a lot of ancillary questions around that about deference and ambiguity and canons and perhaps the written law, but I think that is the nub of this argument, which Mr. Hollers just said is his legal interpretation argument, or the abuse of discretion by failing to properly apply the law. The core of United Advertising's argument is that their reading is the only reading, the only reasonable reading. And I think from the pattern of the city's practice, from the presentation and the record before the board, most importantly, and from the district court's interpretation, which is sort of no moment here, since in this posture on a 106, you're not reviewing the district court's ruling, you're reviewing only the board's action, but still another indication that there is more than one reasonable way to read this statute and to read that particular clause oriented to the interstate. I think, Judge Young, you went directly to the heart of our argument, which is that that phrase needs to be read in context not just of that particular sentence in the code, but in the context of the whole billboard code, and including the map of where the billboards are allowed, and in the context of the history of billboards in Wheat Ridge, which used to be very loose, as the staff put it to the board in their presentation, but which, starting in 1991, became very restrictive, right? First reducing it to just the zone, and that zone that Mr. Hollers pointed to, which extends for some distance to the north of the interstate, was created in 1991. But this phrase added in 2007 further narrowed it, right? So although it did not explicitly say, well, there's a particular distance from the highway which is forbidden, it did say that these billboards, to be billboards, have to be oriented to the highway. And the city consistently interpreted that to be a combination of proximity and visibility, along with other factors such as the grade between the highway and the billboard, and what other trees or buildings might be in between, and other matters which are which affect the determination of whether, looking at the billboard, the board can say that is oriented to the drivers on the highway. Judge Yoon?
No, I didn't have any questions.
So, just to address some of the specific points that Mr. Hollers raised, I was surprised to hear him say that this interpretation is unpublished and unknowable, since his client was notified of this interpretation not once but twice. Right? They applied for this location first in 2018 and received a letter saying this does not qualify for our lottery because it is not oriented to the interstate. They did not appeal. They did not take any action. They simply applied again in 2022, received a very similar letter saying, just as we told you in 2018, this is not oriented to the interstate. You do not qualify. And added some language to explain further, we interpret the term oriented to mean clearly visible from the highway. The term clearly visible, not part of the ordinance. At the presentation to the board, more precisely, the staff explained that what they meant or how they interpreted the phrase was reasonably visible, including proximity, grade, and the other factors it talked about. In other words, a functional contextual determination. And that is a reasonable interpretation of that phrase, particularly, as Judge Dunn suggested, in the context of figuring out, is this billboard a thing meant to be seen and meant to be seen by travelers at high speed on the highway? Is that thing oriented to the highway? Now, what I still don't quite understand, even though this argument has been hashed out first in the district court and then again here, is United's response to our argument that the word cannot simply mean pointed to the interstate or facing the interstate, because that would lead to some absurd results. You could have a billboard that was somewhere in the zone. The examples in our briefs are in an underground garage or in a forest or behind a large building that is literally pointed toward the interstate, but is not visible at all from the interstate. And that would, under UAC's reading of the code, be a billboard oriented to the highway. And that seems unreasonable. That seems even absurd. Right? That would allow billboards that are clearly pointed at something other than, directed to, oriented to something other than the interstate highway. Right? And in the reply brief, here, UAC responds, well, in that case, they would not be facing the interstate. They would be facing the building or the forest or whatever it was they were pointed at. In other words, to avoid the absurdity, United retreats to a functional definition, right? It no longer means the abstractly pointed to or pointed towards a highway. It means you have to look at its surroundings and what is it actually facing? What can be, who can see it? Is it the other building or the squirrels in the trees or whatever hypothetical we're talking about? And so I am no longer sure what rule United is asking for. If they are still asking for what they asked for initially in their appeal for an interpretation from the board, which was, we would like you to interpret this statute to have no requirement of visibility. Right? If that is still their position, then I don't see how they avoid the absurd results that make that definition unreasonable.
But I thought there were particular zones where billboards could be, certain locations.
Sure, there is one zone,
Yeah.
the B2 zone,
Yeah.
and it's mapped out in several different places in the record before the board. But what UAC asked for was an interpretation saying that as long as it's in that zone, if it is pointed towards the highway, it's oriented to the highway, because that's what the dictionary says definition 1 of oriented to is, right? Pointed at or directed towards. So if you are in that zone in an underground garage and you point your billboard in the general direction of the highway, then I believe that satisfies the definition of oriented to that UAC was arguing for below and arguing for in its briefs here. That seems to me unreasonable and absurd, and certainly, more importantly, not as good an interpretation as what the board accepted from the staff here. If that is, if they are no longer taking that strong form, then I am not sure what the definition is that they are asking for, because as long as you back off from that extreme or abstract definition of oriented to, that is to say pointed towards or facing, and start considering where it is and what it's, what's between it and the highway, then you're doing the same thing that the board did here, which is taking it in context, giving it a functional definition, saying, okay, we're going to look at where it is in the zone, how close it is to the highway, what's in between the highway and the sign, and that's how we're going to make our determination of whether it's oriented to the highway.
Let me ask you, if we find the ordinance ambiguous and we give deference, what council says that we don't give any deference. What's your position?
I don't think we have any disagreement on that point. The law has been for a long time that deference is advisory, not binding, and it depends. There are different ways that this court and the Supreme Court has articulated that. Sometimes they say we give great deference. Sometimes they say we give whatever deference is due if it's not unreasonable. So it's given different formulations, but I think the nub is if you have two reasonable interpretations and you have one that the experts at the agency have decided to go with, that is one of the persuasive aspects you can look at, one of the canons of statutory interpretation that you can rely on to determine what the statute means.
Let me ask you about the party presentation argument. Counsel argues that you violated the party presentation rule at the trial level, I guess, 106 proceeding, because you contended that the ordinance was clear and unambiguous.
I don't think that's what he's saying. I think what UAC, at least what they argued below to the district court, and again, let me preface this by saying you're not reviewing the district court, you're reviewing what the board did. And so in a sense, what the district court did with our arguments below is immaterial. And so the question is, what did we argue to you here? And what did we, more importantly, what did we argue before the board, and what did UAC argue before the board? That's an overarching sort of procedural question or a review question. But what I believe UAC's argument was below and again here is that we did not use the word ambiguous in our answer brief before the district court, and that amounts to a concession that the statute is unambiguous. The first part is true. We did not use the magic word, and the statute is ambiguous. Nor did United Advertising in its opening brief to the district court use the magic word, this statute is unambiguous. Regardless, I don't think there's a magic word requirement that applies in any of these situations. What we did argue is, as we argued here again, and as the staff gave to the board below, is that here are all the reasons why we define this word this way, right? And that here's how United Advertising would like you to interpret the phrase oriented to. Here's another reasonable interpretation, the one that we have used since 2007 when making these determinations. That is, that is the sum and substance of an argument that this statute can have more than one reasonable interpretation, and that you need to go beyond the plain language.
Let me just ask you something. Hypothetically, if you had argued this is unambiguous and here's our interpretation, because we have de novo review, it's a legal question, would it matter?
That was going to be my final point. It would not, right? This is a purely legal question of statutory interpretation. Even if Mr. Hollers and I had walked in here with a stipulation saying this statute is unambiguous or this statute is ambiguous, you would not be bound by that. You would still do your own determination of first, the threshold question of whether this is susceptible to two or more reasonable interpretations, and then if it is, how you walk through the canons that are applicable here to interpret what that meaning is and whether the board misinterpreted it and abused its discretion. If there are no further questions, I will yield the rest of my time.
Thank you. I believe you have about 3 minutes.
Thank you, Your Honor. I want to make a few quick points in reply to Mr. Klingsborn's arguments. Mr. Klingsborn mentioned that during the BOA hearing, staff advocated that oriented to should mean reasonably visible instead of clearly visible. That shows further that the city's definition of oriented to has been inconsistent. It's been inconsistent within the bounds of this specific dispute, starting from clearly visible, moving to reasonably visible before the BOA, and then the district court, and now this court. And additionally, in the past, the city has not applied a visibility requirement, especially to that 2018 billboard that I talked about earlier.
So I guess to counsel's, question or point, what definition are you asking for?
Yes, so we are asking for that it be like the City of Brentwood case, the Tennessee Court of Appeals case that both parties have cited, that it be facing I-70. And to respond to defense's absurd results argument, our point with respect to our response to that argument is that, for instance, right now, I am oriented to your honors. I'm not oriented to the building next door or any building past that. No reasonable person could say that. There's a limiting principle there. It's not a visibility requirement. It's, do those objects have some sort of direct relation to each other? We right now have a direct relation. I don't have a direct relation to the building just to the south of the Court of Appeals and Supreme Court building. Similarly, if a billboard were hidden in a forest but abstractly in the direction of the highway or in a basement somewhere, it wouldn't be oriented to the highway. It'd be oriented to the wall that it's facing or oriented to the edge of that forest. And we talked about economic realities with respect to billboards, and that really gets to the point of it. While in the abstract, I may be oriented, I believe, to the south, a billboard business isn't going to put a billboard where it can't be seen. That doesn't go necessarily to the legal interpretation. It's just not an absurd result that would ever actually happen. No one would do that. With respect to the party presentation rule, we did argue below that it was unambiguous in the legal standards section of our opening brief to the district court. UAC argued or set out the legal standard that if a code provision is unambiguous, then you start and end with a plain meaning analysis. We then put forth a plain meaning analysis. The city never contested that in its answer brief below.
And I guess the same question then, why does it matter if it's de novo review?
Running out of time, may I
Yes.
answer the question? Thank you. It matters because it evidences where the district court went wrong. And while this court's review is ultimately of the BOA below, it does have to look at what the district court did and how it got to its ruling. It started off with an ambiguity finding that nobody had argued and then moved into deference based on an ambiguity finding. There should have never been an ambiguity finding in the first place, and the analysis should have started and stopped with a plain meaning review.
Thank you.
Thank you. Thank you
Thank
for
you.
your fine arguments. The case will be deemed submitted, and a written opinion will issue in due course. Case up is Jacobs versus Fort Collins, and I noticed that some of you came in a little later, so I'll go over a couple things. Each side has 15 minutes to make their argument. Appellant could reserve rebuttal time, but you'll need to keep track of your own time. We have a clock that helps you do that, and we also have 3 lighting system. The important part is when the yellow light comes on, you only have 5 minutes to give you kind of a gauge of where you are. And if you have a cell phone or something that sound could come up, please turn it off. And we have a right toggle switch that will help you lower or raise the podium. And if you have any kind of, I don't think you do, but if you have any kind of confidential or sensitive information, please be aware that we are live streaming the arguments. Unless council have any questions, we are ready to proceed with the appellant.
It's been a while. Do I start this myself or do you guys start it?
They will start it when you're ready to go.
Good afternoon. May it please the court. My name is Tim Feeney, 41508 with Nathan Dunn Mayor. I represent the Fort Collins Loveland Water District in this matter. During this short statement, I will refer to my client. I'll try to as the Water District to avoid confusion with the district court below. I'd like to take a moment at the outset to thank the entities that helped and provided an amicus brief in this matter. And I'd also like to introduce Amanda Proctor, who is here from the Fort Collins Loveland Water District. I'll try and strive to keep my statement brief, reserving time for the court's questions and if appropriate, rebuttal. With that, I'll begin. As the court is undoubtedly aware, the Colorado Governmental Immunity Act provides governmental entities in Colorado immunity from tort or tort-based claims, subject to limited waivers. The purpose of the statute is sound. Governmental entities in Colorado provide essential functions, and just as here, the district provides clean water for commercial and residential customers. In order to provide those services, entities are required to maintain tight budgets pursuant to Tabor, and their budgets are funded by resident customer constituents. Without the CGIA, entities become giant targets facing nearly unlimited liability. The restrictions of the CGIA may seem unfair to some individuals. However, the legislature felt it was necessary to protect not the governmental entities, but instead the citizens from excessive taxation that would result from that unlimited liability. Thus, the CGIA strikes a balance between furnishing plaintiffs in appropriate situations remedies that would otherwise be unavailable, and limiting expenditures that can disrupt the provision of essential services. This case also obviously involves the ERS, which is the excavation requirement statute. As the court's likely aware, there's a dearth of case law, presidential case law on the requirement statute, which has been, or I believe originally enacted in 1981, revised in the 90s, again in 2008, and then again recently in 2016. That statute, known as the Call Before You Dig statute, requires utilities and imposes requirements on utilities and excavators. As applicable here, the district, upon receipt of a notice from the statewide 811 system, notified of Colorado Boring's intent to dig, was required within 2 days to utilize reasonable care in providing markings, in this case, blue spray paint or a blue little flag noting the understood location of its line. I'd also like to remind the court that Colorado Boring is a private for-profit company that has sued the district for damages of delay, unabsorbed overhead, investigation, reputational harm, and statutory attorney's fees. These damages arise from Colorado Boring's breach of the district's water line. Stated simply, they're suing us because they broke our line. Nobody disputes that the district promptly responded to the request for information, or that notice was not provided that lines were in the area. For the purposes of this, parties have stipulated, and for the purposes of this appeal and the case below, we have not disputed that the marking was outside of a 36-inch area. In fact, it was a mere 18 inches outside of that area. But we're not here to determine whether that constitutes reasonable care. We're here to determine, or ask the court to determine, whether or not the act of performing a locate in accordance with the ERS can subject a public entity to liability. The Water District, in relying on the only cases to ever address the ERS, assert that the Supreme Court, as clearly stated in the State Department of Highways versus Bell Mountain Telephone and Telegraph, that the ERS does not impose liability on a governmental entity. Even though a statutory duty is imposed through the ERS, that does not create a waiver under the CGIA. As the court is aware, the CGIA contains all waivers to governmental entity, and that's stated within the CGIA. Subsequently, in 2008, after State Department of Highways came out, assuming the legislature was aware of it, the legislature said, we defer to the CGIA with regard to damages under the ERS. It did not create an additional waiver for compliance with the ERS, and it's our argument.
Sorry, I just want to make sure I understand the argument. You mean in the amendment or the enactment of the ERS, the legislature was aware, obviously, of the CGIA, and they didn't include an additional waiver of immunity? Is that your?
Yes.
Okay.
Yes. So it's assumed that the legislature was aware when it amended the ERS to include, I believe it's 9.1.5. It says subsection 4. 104.5 subsection 4 that says nothing in this article shall be construed to impose an indemnification obligation on any public entity or alter the liability of public entities except as provided in the CGIA, i.e. referring to the CGIA saying if there was a waiver, it's in the CGIA, but at the time, there was a clear holding by the Supreme Court that said that ERS does not waive under the CGIA.
So can you help us understand why locating and marking a water line doesn't fall within the waiver, or does fall within the, or does not
It doesn't fall within the waiver.
Yeah.
So
waiver of the operation and maintenance of any public facility. Can you focus on that?
Absolutely. So operation of the public water facility constitutes the collection, treatment, and distribution of water. Nothing in the act of providing information concerning the location of a utility is in furtherance of that action. The Awad v. Breeze and all the cases cited in our brief are pretty clear that this is not likely operation. Maintenance is, I believe, also the issue. As Judge Dunn is likely aware from the smoke brush case, maintenance is also a defined term, and maintenance broadly construed encompasses ongoing repair and upkeep of a facility to put it back to its original condition, and that's from, I believe, Padilla, X-Rel Padilla, which was cited in smoke brush.
How do you respond to opposing counsel's argument that arguably part of operating a water district requires making sure the lines generally are not declining? How do you respond to that argument?
I mean, this line was just sitting there providing its perfect service and was operating. It didn't need maintenance or repair until after it was breached. There was nothing that required this maintenance to be brought back to its original condition until it was breached. We'd argue that that was the maintenance aspect of this case, but that's not what we're here for. We're here for the marking. I believe that.
Sorry, I'm just trying to make sure I understand. So with respect to marking a line, does that duty not arise unless somebody makes a locate request under the ERS?
That's correct.
So there's no other instance where the water district would just be marking the line?
No, yeah. And they're literally just out, and they only do so when prompted, have to do it within 2 days, and utilize reasonable care to put down literally the blue spray paint or the blue flag on somebody else's property, on a sidewalk, wherever the dig is supposed to be. We have to go out there and provide that.
It's a little hard to tell what the district court used operation maintenance, but without citation to cases, it seems based on the Supreme Court precedent that operation is maybe the closer one in terms of if you were to mismark, and we broadly construe waivers, wouldn't that lead to disruption in service? So in that way, could it potentially fall under operation?
I mean, would it? Because we don't plan their bore path. They say this is the area where we're digging, mark every line in this area. They have the last best chance of looking at it. It's not like we didn't tell them our line was in the area. But again, we're not here for that. Is the act in furtherance of gathering water? I would argue no. Is it for treatment of water? I would argue no. And is it in furtherance of distribution? I would still argue no. And that the water district was providing that distribution up and until the line was breached by the plaintiffs. And then with regard to maintenance, I believe Swakowski, Padilla, and Galef are all directly on point, the most recent case being Galef, which was a dangerous condition failure to warn case. I don't believe directly applicable here, but that involved the University of Colorado actually performing maintenance, directly interacting with the facility by mopping it. In that case, they put the sign on the other side of the stairs and somebody slipped. But they had actually performed the physical act of maintenance. Here, I don't believe that responding to a call or a request for information falls within maintenance, and I believe, or operation, and I believe that the Richland development case is directly on point there too, in which a division of this court found that provision of information upon a request to a water district is not part of the operation. And we just urge that the court, even in applying the waivers broadly, don't make it so overbroad that just having a water district licking stamps, putting mail or sending out invoices is operation. I believe that there are still tasks and there's still case law, PAC v. Anderson Valley, Richland Development Company, that show that there are tasks that a district undertakes that are not necessarily in direct furtherance of the treatment, collection, and distribution of water or the direct repair of their lines. With that, any questions? Thanks. I'll reserve the rest of my time.
Good afternoon, Your Honors. Excuse me. My name is Dan St. John, attorney registration number 46653. I'm here with Dan Muffley, and together he and I have the pleasure of representing Colorado Boring Company, which is a trade name for Jacobs Investments, LLC. Colorado Boring requested a utility locate before beginning an underground boring project. Fort Collins Loveland Water District mismarked the location of its water line when responding to that utility locate request, which caused Colorado Boring to crash into the line. This damaged the line and stopped the distribution of water through the district's pipes to the district's customers.
Can I ask you a preliminary question? Are there any disputed issues of material fact relevant to the governmental immunity?
No, there are not, Your Honor.
So it's undisputed, so we could review it de novo?
Yes. Yeah, that's what I was going to get to. The issue is whether locating and then marking the location of those underground water lines to preserve them from damage from excavation is a waiver of governmental immunity, because locating and marking those lines is operation and maintenance of a public water facility.
So can you help me understand why locating and marking a water line is not ancillary to the collection, treatment, or distribution of water?
Certainly. And I think the water district has relied heavily on Richland development to talk about providing information is ancillary to the distribution of water. There's a distinction between the mere providing of how many taps there are for sale in Richland with the interactive process inherent in locating and marking underground water lines that was involved in this case. The ERS, and we briefed this in our answer brief, sets out a very thorough procedure for what one has to do when responding to an 811 call. It's much more than just looking at a map and providing a map. You have to go on site You have to use reasonable care, and when I say you, I mean the water district as the owner and operator, has to go on site. They have to physically locate, they have to use reasonable care to locate their lines, and they have to mark it on the ground. Now, the purpose of that marking is to preserve these water lines from a foreseeable hazard. That's what the excavation requirement statute's purpose is. It's to prevent damage to property and injuries to person. So when you go on site,
So you're making an argument on maintenance or operation? So I'm trying to focus on how is it related to collection, treatment, and distribution of water?
yes,
I'm not saying it's not completely unrelated, because obviously the issue is whether it's ancillary or primary to those purposes.
so the ancillary argument is under operation. You look at the concept, in addition to what I was discussing about how it's an interactive process that requires affirmative present action by the water district, you also look at the consequence of what happens if the water district fails to use reasonable care in locating and marking its water lines. As happened in this case, because of the mismarked line, Colorado Boring bored through the water district's water line, which stopped the water district's ability to move water through its facility. The water was turned off to its customers. Further, there may have been some contamination issues, which was also a purpose of the water district. So the locating and marking requirement doesn't physically require you to touch the water line, but it does require you, again, you being the operator, to take steps to ensure that the water continues to flow through. So if the water's not flowing through, it's not distributing, it's not accomplishing the purpose. Turning to maintenance, the case law that Water District has relied on, which includes AIG against Edwards Excavation, a federal district court case that's not binding on this court and that is non-precedential and the court should not adopt. That case was decided in 2016, but it cited Swikowski against City of Fort Collins and Medina against State, which were both Colorado Supreme Court cases from 1997 and 2001. These cases discussed the definition of maintenance under the dangerous condition provision of CGIA. In 2003, however, the General Assembly amended the CGIA to add a specific definition of maintenance, where there was none before. The definition added in 2003, which is 2410-103-2.5, included the Medina and Schweikowski definition, but importantly, added a component to maintenance, which was to preserve a facility from decline or failure. That takes us out of the restoring a damaged line to the status quo. This preservation component added by the General Assembly in 2003, after Schweikowski, after Medina was decided, shows that these water districts and these operators of public water facilities have a present obligation to protect their lines from damage or failure. This again comports with the purpose of the ERS to protect property.
So you're
from
focused on
damage.
the failure part of the language rather than decline?
Yes, I am focusing on the failure.
But doesn't the context of this suggest failure by poor maintenance as opposed to a third-party source, like your company drilling in?
I would
Wouldn't it
say
be more like repair from an accident?
well, the preservation component, I mean, this is where we look at Galef against University of Colorado, which is the only case we have that discusses maintenance under the CGIA and the preservation component. In Galef, the University of Colorado maintained its dormitory by mopping the floors to preserve them from decline. Yes, it was touching them, but it wasn't doing anything to repair those stairs. The mopping aspect is the same aspect as the excavation requirement statute puts on the water district. It's not, the ERS is not the marking and locating requirement under the ERS is not a favor that water district does to excavators. The purpose of that locating requirement and marking requirement is to protect the lines from damage, from a foreseeable and known damage of excavation. So by taking the preservation component of maintenance, yes, you would need to repair the water line if it was damaged. That didn't happen in this case. You need to preserve it and protect it from decline, which is what what the purpose of the ERS is.
But, I mean, I guess under your argument, wouldn't the water district have, presumably the water district wants the water to run, correct?
Yes, Your Honor.
So why does, I guess, the ERS implicate a duty, a maintenance duty? Because I guess my question is maintenance can occur regardless of whether somebody asks for a locate. Is that correct?
Yes, Your Honor.
All right, so doesn't that cut against your argument that the ERS then, I guess, imposes some duty to, some maintenance duty with respect to request to locate?
Well, I don't think the ERS imposes a duty, at least in terms of something that waives governmental immunity. You still have to analyze the governmental immunity waiver under the CGIA. But yes, you can maintain, as you're discussing, they can sweep the lines or do some sort of active maintenance. But the addition of the preservation component, requires that present conduct done to make sure that the line doesn't fail. Now, the reason we have it in the locate and the excavation requirement statute is because we know that there's going to be excavation. When you call 811, you tell basically the operator that you're excavating in this area. The underground environment is very crowded where these utilities are. It's a crowded right-of-way. So that's why it's incumbent to protect and preserve the underground facility by using reasonable care to accurately locate these lines and inform the excavator so that the excavator can plan its bore path to avoid impacting the water line, which obviously damages the water line. It prevents the water line from distributing water to the customers of the water district.
Understanding that, how do we then get from, and accepting all those things as true, how do we then get to a finding of, or conclusion that immunity has been waived, especially in light of State Department of Highways versus Mountain States telephone?
Well, Mountain States was a case that says, let me turn to my notes on Mountain States. It says that the ERS in and of itself does not create a waiver of governmental immunity. This comports with the purpose of 104.5 subsection 4, which is a signpost that says, courts, when you're considering this, look to the CGI to answer that very question. Mountain States was a failure to maintain a public highway. And the facts of that case involved basically doing some work around a billboard or something like that, which fell over and injured some people. Now, that maintenance of a billboard doesn't have anything to do with a highway. Here, marking a water line, as I've discussed before, directly implicates the operation and maintenance of a water district, because if you do it wrong or if you do it negligently, the water shuts off when a boring drill head crashes through the water line. So I would distinguish those. I don't think Mountain States said categorically that the ERS never creates a waiver. I think what Mountain States says, and it jives with 91.5, 104.5 subsection 4, look to the CGIA to answer that question. The key issue in this case is preservation. Water District has relied on an old definition of maintenance from Swikowski and from Medina, which was adopted incorrectly by AIG, which does not incorporate the preservation from decline or failure component within the current definition of maintenance. Locating and marking lines is an act of preservation to protect the Water District's lines from a decline or failure in this case, due to a known hazard of from excavation. The ERS is designed in part to help owners and operators like the Water District protect their facilities. As I mentioned before, locating a water line is not a favor to the underground boring company, to the excavator. By preserving the lines from decline or failure by marking them, water facilities are able to continue operating at their core purpose, delivering water through their pipes from their their water treatment plants to the customer's tap without interruption from excavation. Without the present act of preservation, which is locating and marking the lines, the Water District cannot operate a public water facility by distributing its water to its customers. Accordingly, because marking and locating lines is the operation and maintenance of a public water facility, the Water District here has waived its immunity in this case. Therefore, the court should affirm the trial court's order denying Water District's motion to dismiss. And unless there are further questions, I yield my time.
I believe you have 4 minutes and 15 seconds.
Yes, Your Honor. Are there any questions at the outset? I would just like to address two things. The AIG case did address Wachowski and Medina, but it was also authored well after the amendment of maintenance to include preservation. The district and I would argue that preservation of a line would, in this case, hypothetically be preservation of a deteriorating line, repair, replacement of a line to ensure continuation rather than simply providing blue paint marks on the surface of the ground to say, hey, our facility is here. With that, unless there's questions, I'll yield.
Thank you.
Thanks.
Thank you both for your fine arguments. The case is deemed submitted, and a written decision will be issued in due course.